Good evening, North Andover, for a special edition of the North Andover Zoning Board of Appeals, July 17th, 2025. We are here virtually as a special session to discuss the procedures for a zoning board review of a 40B project. As some of you may or may not know, we as a board have not handled a 40B in town for quite some time. And as a result, I believe all members of the board have not yet experienced a 40B. And so the town manager was kind enough to bring in a law firm to help us understand a little bit about what the zoning board's responsibilities are, what we are allowed to discuss, what we are not allowed to discuss as a board, and to better understand the role of us and the larger community in this project. And so here to help us out is Carolyn M. Murray, Esquire from KP Law, and she'll be here to guide us through this process. Members here will be able to ask questions, and this will be available to the public. If you are watching now, you are probably watching on either our North Andover CAM website or on, I believe it is channel 8 on Comcast and channel, I already lost what channel it was on. It is channel 22, I want to say, on Verizon. And this will also be posted on YouTube. So for anyone that misses, it will be available for posterity. Thank you very much. All right, Carolyn, can you introduce yourself and walk us through this a little bit?
Absolutely. So thank you to members of the board. As you said, I'm Carolyn Murray. I'm a shareholder at KP Law, and we've been brought in as special counsel for the purposes of assisting you with this training tonight. Just a little bit about myself. I've been practicing municipal law for well over 20 years now, and I'd say that more than half of my practice at this point consists of advising zoning boards such as yourself on 40Bs. Particularly lately, there seems to be an uptick in activity statewide. But when I don't have my 40B hat on, the rest of the time, I'm just sort of a normal land use attorney. So I'm very familiar with what zoning boards, planning boards, conservation commissions, et cetera, do. As you're saying, Mr. Chair, in your opening remarks, I will put a PowerPoint presentation up shortly so that we can all sort of follow along with like the basics. But my feeling towards a training is always, this is for your benefit. You know, you don't need me to sit and read what the written word on the page to you. You are all very capable of doing that yourselves. What I encourage is any questions as they should happen to come up, or sometimes we might go off on a tangent here and I'll try and bring us back. But please feel free to interrupt, and I may not necessarily be able to see once the PowerPoint presentation is being screen shared. So if somebody could please let me know if there's a question out there, I'm happy to stop and take them as they come. So with that, I guess I would ask Jean if she could put the presentation up. And I think, Jean, I'm also going to have to impose upon you to advance to the slide. So if we just go to the very next one, please. Go ahead. Thank you so much. So this is just our general disclaimer before any sort of a training that, you know, this is obviously for the purposes of providing information to all of the board members, but the purpose tonight is not necessarily to discuss any specific application that has been before you, that might be coming before you, or that is scheduled to be heard in the coming weeks. The purpose here is really that this should all be hypothetical. And part of the reason for that is, as you know, every decision that you make as a zoning board member should be based upon information that you receive in the context of the public hearing. So we wouldn't want to start going on down a rabbit hole of discussing a specific project perhaps in the past, or one that you think might be coming in any way that might sort of prejudice the process going forward. So I just ask everyone to bear that in mind. So if we could go to the next slide, please. Thank you. So just as a general introduction, since the chair mentioned that this is something that is a relatively new process for all of you, for however long you've been on the Zoning Board of Appeals and you have been handling variances and special permits or non-conforming uses, alterations, all of that, pretty much all of that you can just purge from your minds right now, because the 40B rules just take everything and upend it, from the quantum of vote to the timelines, except to the standard of approval, et cetera. So we're going to go through all of that, but I'm sure that there will be times where you say, wait a minute, but that's not how we normally do things. Again, it's an entirely different statutory scheme. So, so we'll start with the basics. It's obviously Chapter 40B, and it's a relatively short chapter consisting of just 3 easy sections to read. But this is the genesis for the comprehensive permit. And that term comprehensive permit is meaningful in that it is literally supposed to be a one-stop shop, that being the Zoning Board of Appeals, for all of the various local permits that might be necessary as part of an affordable housing project. So you as the Zoning Board of Appeals, you might put on a planning board hat. You might also act as a historic district commission. You're looking at things from a conservation perspective under your local bylaws or local regulations. You're acting in place of water and sewer boards or DPWs when it comes to, say, curb cuts or water connection permits, all of that. And those are things that typically you might touch upon in the context of a hearing, but they aren't necessarily things that you are literally granting the permit for someone to be able to proceed. Now, that can sound a little intimidating because, like I said, most weeks you're not dealing with septic systems or wetlands. Those go to other boards with jurisdiction. You're not acting in a vacuum. You are supposed to, by statute, you're supposed to distribute that application to every single local board and department in town immediately upon receipt. And the purpose of that is so that you can get their feedback and, more importantly, take advantage of their expertise when you are actually going to start acting on the comprehensive permit, because you're going to want input from all of those various disciplines.
And do boards, in your experience, often bring in those other boards to public meetings? Do they typically discuss leader to leader? How does that usually play out?
Typically, every once in a while, I don't necessarily see the other boards come in. I will see, for example, a DPW director might come in and talk about water or sewer capacity. You might have like a health director who comes in and explains some of the impacts of maybe the Board of Health's local regulations that are at play here. So usually it's not inviting, say, the other board in, although there's no prohibition against that, especially if there's some value to that you might want the chair of another board coming in. But typically it's in the form of the board will, at their own separate meeting, they'll discuss the application. They'll instruct staff to put some kind of a memo together. That all gets delivered to the Zoning Board of Appeals. And if it requires, further discussion, the zoning board might say, gee, could we please invite the health director to come in to our next meeting and participate in this portion of the discussion. One thing I do want to be clear about, although you're acting in place of all of your other local boards, you're only acting with respect to local regulations. So, for example, when I said that you act in place of the Conservation Commission, you act in their place only with respect to a local wetlands bylaw or local wetlands regulations. You're not acting in place of the Conservation Commission when it comes to matters of the State Wetlands Protection Act. Similarly, with the Board of Health, if the Board of Health has local septic or maybe well regulations that are impacted, you're going to act in place of the local Board of Health as it pertains to those local bylaws or local rules. If there's something, however, that arises under Title V, the state septic system regulatory scheme, that will go through the Board of Health separately. So sometimes there is a sort of delicate dance of identifying what comes within the zoning board's purview versus what does not. And it's supposed to follow up on that, on your question, Mr. Chair. I usually do see that the other boards or their staff will provide as much support as they possibly can to the zoning board, especially when they recognize that this is not usually an area that they have to address in normal permitting. One thing that is also a common question that arises from folks is that 40B allows a developer through the ZBA to literally override all zoning. And I still get questions from boards that will say, well, how can they do this in the commercial zoning district where we don't allow, say, multifamily uses there? You can override use regulations. You can override all of your dimensional regulations. It really is kind of astonishing sometimes how many requests there are to completely override zoning. And that can be hard when what you're used to is using your zoning bylaw, as your guide throughout all of this. Hand in hand with that.
Along those lines,
Mhm.
if they are allowed to overrule much of our zoning, then what is the reason for all of the hearings that we're going to have? Right? Couldn't they just then do whatever they want? Why do they come to us?
Well, it's a good question. I can only say, in the wisdom of the legislature, I don't think they wanted to take all local authority away. I think they wanted to give municipalities, some input in the design and shaping of these projects. But you're right. Someone could literally come in, not that I've seen this happen, but someone could come in and virtually need a waiver from pretty much all of your zoning requirements. That's highly unusual. There's usually some that they comply with, but I think as best as I can see the insight of the legislature, I think it is to give some sort of recognition that regardless of how powerful this statute can be from a developer's perspective, they do want buy-in at the local level, or they do want you to have the ability to at least participate and try to shape the project as best as possible, since it will be in your communities.
You mentioned they might need waivers from our local regulations, but they don't actually need a waiver, right? We don't grant a variance or a waiver.
You will not be granting variances, but you will grant waivers. And the reality is that there's not much of a difference in terms of the term that we use. But, when you are typically looking at a variance under Chapter 40A, you're looking at the shape, soil, and topography of the site and a hardship that's been presented. Here, they're called waivers, and the applicant is required as part of their application to submit a list of waivers. Sometimes they call them a list of exceptions, but they are supposed to identify every provision of your zoning bylaw that they are going to be requesting a waiver from. And then the zoning board will go through those waivers, usually towards the end of the public hearing process. And you will go through them and vote on each one of those. So, but you will not be applying the standard of shape, soil, and topography like a variance. Instead, we look at a different standard, which is consistency with local needs, and as that local need, whether or not it outweighs the need for regional housing. It's kind of a cumbersome term, but we'll talk about it in a little bit more detail as we go through.
Okay, I was about to ask a question, but I'll hold off until then.
Or
Okay.
just what, if, do we have the option of not granting a waiver? Or can they just ignore it?
You absolutely do. You absolutely do. If you decide not to grant a waiver, it's supposed to be based on some sort of local concern. And maybe we're getting a little ahead of ourselves.
Sorry.
But yeah, so why don't we kind of skip ahead a little bit, and I promise we will get there. So backing up just a little bit, typically before an application comes in, we encourage boards to do almost exactly what you're doing tonight, which is have a training. If you haven't had one of these come before you ever, or if you haven't had one come before you in some time, it's always good to have a refresher on, gee, this is a totally different animal, and how do we approach this? So we always encourage folks, engage in a planning process or a training process. If you haven't updated, or you don't have a certified housing production plan, now would certainly be a good time to take a look at, gee, where does that stand? Because perhaps it's in the process of being updated, but certainly can serve a benefit to you when it comes to a safe harbor.
We do have a housing production plan set up.
Okay. I don't know that the state has that one listed, because I think I checked their certified list, and I don't know that they've got it updated, but they might be a little bit behind in updating. But good. You know, sometimes also taking a look at your master plan or your open space plan and seeing, you know, if no one has looked at that in 10 or 15 years, maybe it's time to see if that could also use some updating in ways that could be beneficial for you in terms of how you approach a 40B. Are there conditions that you might want to impose upon a 40B that further some of the goals of those other plans? So if we could go to the next slide. One other thing we suggest you do is update your comprehensive permit regulations to the extent that you have any, or if you don't have any, consider adopting some. You know, one of the reasons for doing that before an application comes in is that everything that you are going to consider, or every requirement that this comprehensive permit is going to be judged by, is going to be, what were the bylaws or the regulations that were in place as of the date of their application. So if there's any concern about looking at some comprehensive permit regulations or updating them, now would be the time to do it if you suspect that there is a 40B looming on the horizon.
I mean, thankfully, our planning board has done a pretty good job of keeping up to date on a lot of these things, especially because we are, as a town meeting community, it is not sort of straightforward for us to change our bylaws on the fly the way that a city might be able to.
Right. You are authorized, however, to adopt regulations.
Okay.
Under Chapter 40B, so gives you a little bit of flexibility that you don't, unless you've got, you know, a charter provision requiring that your regulations go to town meeting. But typically, the regulations could just be adopted by the board. One of the most important things to look for, and I'm sure you have them in there, is a provision for consultant fees. You know, Chapter 44, Section 53G allows a local board, such as a zoning board, planning board, conservation commission, basically any board that's in a position of granting a local permit. You can, if you don't have in-house technical assistance for certain areas, like suppose you need a stormwater engineer because you don't have somebody on staff who is well-versed in stormwater standards, or maybe you want a traffic engineer to look at a particular project. Maybe you even, there's a particular need for landscaping or an architect, and those are typically disciplines not found in municipal government. If that's the case, you can require the applicant to pay for your peer review consultants who look at all of those aspects of the studies and plans that are presented by the applicant. So, you know, that's usually the thing I look for in 40B regulations, is making sure that tool is available, because similar to your question earlier, Mr. Chair, about whether or not, you know, other boards will come in and assist with their their disciplines and help you, you're also going to want peer review consultants to look at the plans and see, do they comply with, the various stormwater standards, for example. So if we could go.
Thank you. All right, thank you.
Sure. So this is where we start to really get into the standard. And like I was saying before, this is different from anything that you do with respect to special permits or variances, that the standard to be applied here is whether or not the denial or the approval of a comprehensive permit is consistent with local needs, meaning that, there's some sort of local rule, and it has to be some sort of public health or public safety concern that's embedded in a bylaw or embedded in a local regulation, and how you square those local bylaws and those local regulations with the overall regional need for housing. Now, I'll stop there for a moment and say, we all know, unless you've been living outside of Massachusetts, probably for the last decade, the mantra at the state level is, we need more housing, we need more housing. And in particular, we need more affordable housing. So that's a pretty high threshold for a municipality to say, oh, no, we're fine, we don't need more housing. You're already sort of starting off at a disadvantage vis-a-vis the state's view of this. So if we're going to say, gee, I'm going to deny this comprehensive permit because we think we've got enough affordable housing in North Andover, or we think that this particular project hasn't provided enough. Oops, did I lose you? It suddenly got.
No,
okay, sorry. The little screen went dark for a moment there. Sorry. Or if we were going to deny a project because we don't think that they provide enough open space or recreational areas, say for, the children and the families who might ultimately live there, we better make darn sure that we've got a written rule somewhere in our bylaws or our regulations about that particular requirement for open space or recreational areas. And we will need to make some sort of finding that need for open space or that need for recreational space somehow outweighs the need for local housing. And that's going to be how you evaluate this, whether we're talking about a request for a grant for a waiver, for example. If you have a minimum amount of open space that's required for, say, a multifamily development, and the applicant is asking for a waiver from all of that, you might say, no, you know what, we have this local requirement for a reason, because people need yards, people need open space, these kids need someplace to go out and ride a bike, throw a ball, play. And these units are going to be inhabited by families. So you might find that that's a reason to not grant that particular waiver, because you think that local rule is kind of outweighs the need for housing. One way we can get around, obviously, this balancing act is whether or not we have achieved what's technically called by the statute a statutory minima, but it's more colloquially known as a safe harbor. And we'll talk a little bit more about that as far as that being a useful tool for possible.
Just to make clear what you're saying, if we say no to a permit, to a comprehensive permit, and the applicant disagrees, who then adjudicates? This goes to the state courts? What level? Where does it go?
Sure. So if you deny a comprehensive permit, the applicant gets to appeal that decision to what's called the Housing Appeals Committee. Now, the Housing Appeals Committee is a branch of the Executive Office of Housing and Livable Communities. So it's a bit, and the Executive Office of Housing and Livable Communities is the same state agency that maintains the subsidized housing inventory. Whether you're at your 10%, they're the same folks that approve applications or approve your requests to add units onto the SHI, or tell you whether you are in fact at a safe harbor. So it's a bit incestuous and overlapping in terms of their common goal, if you will. So the first step of an appeal for a developer is going to be the Housing Appeals Committee. From there, whoever is unhappy with the Housing Appeals Committee decision, whether the town loses and wants to appeal, or whether the developer loses and wants to appeal, the next step is that then goes to Superior Court. And from there, it can go further on to the appeals court if necessary. Now, if you are in a abutter and the Zoning Board of Appeals has actually granted the comprehensive permit, abutters can only appeal to court. They don't get to go to the Housing Appeals Committee. An abutter sometimes is allowed to intervene in a Housing Appeals Committee appeal, but they don't have that initial right to appeal directly to the Housing Appeals Committee.
And it is only abutters that would be able to appeal in the first place? In other words, not other community members from further away?
It is similar to a same thing that you're familiar with under Chapter 40A, that, I mean, anyone in theory can appeal, but somehow or other, you have to be a party in interest. You have to be a party that's aggrieved by the grant of this permit. And so typically that means you're an abutter, or an abutter to an abutter within 300 feet, because there is more likelihood that you are impacted by a 40B development versus, you know, I'm somebody who's across town and I can't complain about the traffic or the lights or, you know, anything really to do with this. It's just that I'm a member of the community and I'm opposed to this project. Highly unlikely that, although they can sue, highly unlikely that the court is going to let that type of appeal go forward without some harm being established. One other thing I did just want to say too, there's also a little in terms of the appeal process. You might actually grant a comprehensive permit, and the developer, if they feel that your grant imposed some sort of conditions that were render the project uneconomic, or going back to the waivers, if the board granted the comprehensive permit but denied a waiver, and as the developer then looks at this waiver being critical to the financial success of this project, if the developer feels that any of those conditions imposed or a waiver denied ultimately renders the project uneconomic, and that's got a specific definition found in the regulations, but it essentially is they had to argue that the project becomes not financially feasible. An example would be that perhaps the site doesn't have adequate water or sewage available to it, public water or sewer available to it. And a condition as well, you've got to bring in a whole new water and wastewater distribution system. You've got to, lay however many miles of pipes to connect and blah, blah, blah. When the developer then looks at what the cost of doing that might be, odds are they would find something like that to render the project uneconomic. So they can appeal, even though you've granted the comprehensive permit, they can still appeal that to the Housing Appeals Committee on the basis that the project can't go forward as is because it's not financially feasible to them. One other thing to just bear in mind too is that even though we're just examining a 40B in the context of that statutory chapter and regulations, there is a requirement built into Chapter 40B that we treat what they call subsidized projects, and all of the 40B projects are all subsidized because they are either getting special financing, low interest loans, maybe tax credits through the state, or it might be that they're getting other technical assistance through the state. All of that qualifies as a subsidy. You are required to treat subsidized projects the same way that you would treat what they call non-subsidized projects. So essentially, if you've got a multifamily project under 40B and you've got a multifamily project that is just a standard, maybe a special permit, maybe it's MBTA zoning by right, whatever it is, you've got to make sure that as you're applying these standards for open space, water, traffic, dark sky compliant lighting, all of that, you've got to make sure that you are treating the subsidized projects the same as you would treat a conventional project with respect to those requests.
So in other words, as zoning board members, oftentimes when we have an appeal, we make a point of taking each case on its own merits and not focusing on previous precedent. But that in this case, precedent does indeed matter.
Exactly. Yes. So if we could go to the next slide, please. So we started talking a little bit about safe harbors, and I'm going to go into a little more detail here because we all know the most commonly known safe harbor is 10%. At least as of June of 2023, the state is reporting that North Andover is at 7.99%. I'm not sure if anyone who is on the meeting this evening has any more up-to-date information than that, but it would be worth checking for an or requesting an updated subsidized housing inventory report as you get closer to actually receiving a 40B application, because odds are those numbers may have fluctuated a little bit in the last 2 years. We also talked about if you have a housing production plan. As I said, the state's website is a little bit behind. They don't have yours listed as being currently active, but maybe it's in progress. But if you do have,
I can clarify. Carolyn, if I can clarify, we did just update our housing production plan, but it's not certified.
Sorry, Carolyn, I muted you because of the echo. You'll have to turn it back on. I'm sorry about that.
Thank you. No, so thank you, Jean. So to that point on the housing production plan, it has to go into the Executive Office of Housing and Livable Communities for certification in order to be able to take advantage of a potential safe harbor. But basically what the housing production plan does is you've established certain goals for how many housing units you hope to be able to create. And if you've created or if you've met that goal prior to a 40B application coming in, the housing production plan may afford you a 1-year or possibly a 2-year safe harbor. It's a process where if an applicant came in and we said, look, we just approved, for example, a project for 500 units. We have passed our housing production goal and we're entitled to a 2-year safe harbor. We would notify the Executive Office of Housing and Livable Communities that this other project has just been approved and that we think we are now in a housing production plan safe harbor. They would then send us a letter confirming whether they agree that we are in a safe harbor. And obviously that becomes important when the next 40B application comes along. So if we could go to the next slide, please, Jean. So here are the most common safe harbors. So like I said, we've already talked about the 10% that everyone recognizes. We've talked about a housing production plan. One of the other ones that you might have heard about a little bit more recently is the GLAM safe harbor. This is if 1.5% of the town's total land area that is zoned for commercial, industrial, and residential purposes is if it is occupied by subsidized housing or affordable housing developments, then you might qualify for this safe harbor. I will tell you, as somebody who just completed an 8-year appeal based on a 1.5% GLAM calculation, it's not as simple as I just made it sound by any means, because there are lots of deductions and exceptions to that. So if there is any thought that you might be at or near the 1.5% general land area minimum, I would strongly suggest, we all get on the phone tomorrow and start talking about how we prove that well in advance of any 40B application coming in.
We can look into it, but I have a hunch that we do not come close just because of how large of a surface area of town we are.
Okay. Another safe harbor that comes up is whether or not you've had a large scale project, a recent large scale project, and it's either consists of 300 units or 2% of your total housing units, whichever amount is greater. Another
what
one
defines recent?
Typically, this is going to go hand in hand with like your housing production plan, that if you have if you've approved a large project and they don't, this is one safe harbor where they're a little bit unclear as to what they consider to be recent. I would say that, more or less we should be looking at, say, at least a, 1 to 2 year look back period, that we might be able to assert a safe harbor based on recently having a large project having been approved. Another one relates to it's called a related application safe harbor. This came out of, I'm sure you can appreciate this, that sometimes a developer comes in perhaps for a residential subdivision, maybe a cluster development or something like that. And they're dealing with the special permit granting authority, who is shaking their heads and saying, no, I just don't see that this is going to be approved. And developers were always quick to say, well, if you don't like this project, wait till I come back with a 40B. You're really going to love that one. And it was threatening, quite frankly, to municipalities. So in response to some of that, when the regulations were revised about 10 years ago, this safe harbor was put in that if there had been a related application filed on the same property within 12 months prior to the comprehensive permit application coming in, you get a 1 year safe harbor. It's basically like a 1 year cooling off period, so that maybe we can reassess, maybe suddenly that subdivision that we didn't like so much before, maybe we suddenly find ourselves thinking, well, a 50 lot subdivision might be better than a 300 unit comprehensive permit, for example. So there is just that temporary timeout. And we've talked about the housing production plan. So we could go to the next one, please. So assuming you have achieved any of the safe harbors, and I would strongly recommend that before we just go ahead and say it, that there is, before that comprehensive permit hearing is opened, there will be some discussion amongst folks in the town and the town attorney about whether or not you are in fact there. But assuming you have achieved a safe harbor, one of the most important things, and perhaps one of the only real benefits in some ways to municipalities in this overall scheme that really seems to be slanted against local control, is you have the right to deny a comprehensive permit on the basis that you have achieved a safe harbor. And if EOHLC agrees that you are in a safe harbor, the applicant has absolutely no right to appeal your denial. So that's probably the strongest tool you have in your quiver, so to speak. You also have the option, however, that just because you are in a safe harbor, it doesn't mean you have to deny the application. You can still go forward. You can hear the application on its merits. Maybe you ultimately approve it. Maybe you approve it with conditions. Maybe you hear it, and at the end of the day, you say, no, we just really don't think that this is in the town's best interest or consistent with our local needs. You can take any of those actions of approving with conditions, or denying it. And as long as you have asserted safe harbor, the applicant cannot appeal your decision. So let's talk about how do you go about actually invoking safe harbor. So unfortunately, one of the things about invoking safe harbor is we've got to act very quickly. So when a comprehensive permit application is filed, we only have 30 days to open the public hearing. You know, so that's a little different from your usual, say, 65 days for a variance. And as we all know, it's got to be advertised in a local newspaper at least once in 2 successive weeks. And I know that in some communities, that essentially means that within 2 or 3 days of getting that comprehensive permit application, you've got to have that legal ad prepared and ready to go to the papers, because they just don't act on them or don't publish as frequently as perhaps they used to. If we're going to invoke safe harbor, we have to provide notice to the applicant within 15 days of opening the public hearing. So essentially, that very first night of the public hearing, that is when we're invoking safe harbor. So as I said, it doesn't give us much time. We then have to provide written notice to the applicant and EOHLC within 15 days, and the applicant can challenge whether or not we have in fact achieved that safe harbor. If the applicant challenges whether we've achieved safe harbor, then EOHLC has 30 days to issue a determination as to whether or not they agree with the town that we have or we have not met safe harbor. If HLC agrees that we have met safe harbor, then it kind of comes down to whether or not the board also took any action when we opened the public hearing to deny the comprehensive permit, or whether we said, we're going to assert safe harbor, but we are going to continue the public hearing on the merits of this, let's say 60 days out, so that gives the applicant time to challenge the safe harbor. That gives the Executive Office of Housing and Livable Communities time to issue their determination as to whether or not they agree that we have achieved a safe harbor. And why is that important? Because if HLC comes back and says, sorry, town, we disagree, you're not at your 10%, you're at 9.99, then we want to be in a position where we can still act on that comprehensive permit. Now, another option that is available to the board is that right when you assert safe harbor, you can also that same night deny the comprehensive permit on the basis that you have achieved the safe harbor. It gets a little more complicated now, because if the applicant challenges whether or not you've achieved safe harbor, that's one appeal process on one track. Yet at the same time, the applicant is also going to have to appeal your denial on a parallel track. It's not impossible. It just becomes a little bit cumbersome, but something to certainly think about if you think you're at a point where you would want to assert safe harbor, to really think about, do you also want to deny the comprehensive permit outright, or do you want to kick the public hearing out and let that safe harbor process play out just a little bit? I will also say that after HLC issues their determination as to whether or not they agree that you have achieved safe harbor, that decision is appealable to the Housing Appeals Committee. And it's an immediate interlocutory appeal that, you know, goes through its own hearing and its own evidence submissions, and you wait for briefing and a decision to ultimately be rendered. That will put the comprehensive permit hearing on hold while that interlocutory appeal goes forward. I often get asked, how long does that interlocutory appeal take? It could take anywhere from 6 months to 2 years. So we could have a long time that we're just sitting around waiting for a decision, and folks will think that 40B went away. It's like, oh no, it may be back any day now. We just don't know when. So if we could go to the next one. So let's start with the basics too of the application that comes in from a developer. The regulations list a number of things that an application must consist of. Your regulations might also supplement that to some extent. But one of the things that an applicant absolutely needs and cannot file a 40B application without is what's called a project eligibility letter, or a PEL. You might have seen, if there is a 40B that's on the horizon out there, you might have received like an initial notice from the developer that they are seeking what's called site approval from a subsidizing agency. And the town gets, 30 days to comment, and folks from the state come down and do a site visit, and ultimately the subsidizing agency, whether this is mass housing, whether it's HLC, whether it is, some other mass housing partnership, they're ultimately going to look at whether they think the site is appropriate for the development. They're going to take into consideration some of the local concerns. But essentially what the subsidizing agency does is they issue a project eligibility letter based on three things. One, is the applicant a public agency, a nonprofit, or a limited dividend organization? They don't, a little footnote to that, they don't necessarily have to have that status at the time that they apply. They just have to say that they will create a nonprofit or a limited dividend organization should the comprehensive permit be approved. They also, the subsidizing agency obviously looks at whether or not they think the project is fundable as it has been presented for low and moderate income. They're going to look at, the pro forma. Do the numbers make sense to them that this is even economically viable? They also then look at site control. And site control can mean, does the applicant own the property? But it can also mean, does the applicant have the property under a purchase and sales agreement, for example? Or is there a long-term lease that is, either has been executed or is in the process of being executed? Those three things are reserved exclusively for the subsidizing agency to review. And if they conclude that the applicant meets all three of those criteria, that is absolutely conclusive. So I have had some communities that when the 40B application gets filed with the zoning board starts to question, well, they're not a limited dividend organization yet, or they don't own the property. And I've been told that purchase and sales agreement expired, or it's not being extended, and all of that. You will also come across some people out there that will tell you that you can appeal the project eligibility letter. Don't listen to them. There is case law out there that it cannot be appealed. So I strongly suggest if somebody tries to sell that to you, do not listen to them. Do not waste the town's time or money on that. But the project eligibility letter is literally like, it's their ticket to proceed. It's their permission to pass go, collect $200 and file, their 40B application with the town. So we could go to the next slide, Jean. I already talked about this. I'm sorry, I covered that in the last one. So let's go to the next page. So the application, as it comes to the ZBA, as I said, the regulations, and I put the citation in there at 760 CMR 56, lists all of the contents that an application must contain as far as the state's concerned. You might have some additional requirements locally, and that's fine. One of the things that I think is important for any zoning board to look at is the filing fee. Sometimes if you haven't had a 40B in a while, filing fees don't tend to get updated. And sometimes I will say, oh my God, that this is only a filing fee. That's great. If fees haven't been up in a while, take a look at them and whether or not there's any need to adjust them. But the filing fee is one of those components of the application that it absolutely must be paid in full at the time of the application. And I noted there the Hanover case. In Hanover, there was a developer who took exception to the filing fee amount and decided that they were going to pay what they felt was a fair filing fee. As I recall, it was, like several tens of $1,000s less than what the town had calculated as the fee. And the town ultimately denied the comprehensive permit for failure to pay the filing fee. And the Housing Appeals Committee upheld that as being reasonable. So keep that in mind when you're looking at your regulations and your fees. So if we could go to the next slide, please. So we talked a little bit earlier about waivers or exceptions. The developer is required when they submit their application to include a list of waivers or exceptions from not just from the zoning bylaws, but from any local bylaws. So for example, if you have, let's say, an earth removal permit that maybe the select board administers, or if you have, a curb cut permit that DPW or highway department oversees, and they're looking for a waiver, whether it's from the amount of the permit fee for that particular permit, or whether they're looking to have some sort of a waiver because let's say DPW has a requirement that curb cuts have to be a minimum width of 24 feet. And they only want to provide a minimum width of 16 feet. That would be a waiver from a local rule that they have to request. I will just to set expectations, the developer will submit a list of waivers with their application, but as with any more complicated project, things are going to change with every single session of the hearing. The board's going to look for changes or perhaps suggest some design changes or other aspects of the project that need to be revised. Maybe we want the building set back a little bit from a neighbor on one side because the other side is just an access easement, and we're not impacting neighbors as much there. Every time we start to tinker with the design of the site ever so little, that has the potential of triggering additional waivers. It also has the potential for nullifying the need for some waivers. So I've had some boards in the past, that have said to me, well, they can't amend their waiver list. They can, and they will, and it will just be a necessary part of the process. So I always suggest, it's nice to get the waiver list at the beginning, and maybe as part of your initial hearing, have a brief overview of the nature of the waivers that are being requested. But my recommendation is, as you're getting closer to the end of the process, when you're getting close to being ready to render a decision, that's when you ask the developer for a revised waiver list, because like I said, things come on the list, things go off the list. And that's really when I think the board should invest the amount of time going through the waiver, one at a time, and asking the developer, why is this one necessary? And, giving the board a little bit of an opportunity to vet the need for each one. The waivers can also include, as I said, it can include a request to waive fees, including permit fees. Different towns have some different policies on whether or not they like to waive fees or they don't like to waive fees. Or maybe there are certain fees they waive. Or I've even seen in the 40B context that sometimes a board will agree, will waive the fees as they relate to the affordable units, but we're not waiving the fee for the entire project. Again, it goes to the prior question that you don't have to grant any waivers, but be aware that even a waiver from fees could be embedded in that waiver list. We talked a little bit earlier about the ZBA getting advice from other boards, so I won't belabor that point. And we've talked about the fact that a denial of a waiver, or we talked about how an imposition of a condition could be considered uneconomic. A developer could also make an argument that if you don't grant a waiver, that could in some way render their project uneconomic. If that type of an assertion is being made for a developer, we're going to have a separate conversation about, all right, show us how, show us the money, show us the pro forma, and walk us through as to exactly how this is going to render the project uneconomic. And that almost becomes like a separate hearing within a hearing. And it doesn't happen very often. So I don't want to spend too much time on it this evening, but just be aware that if something like that should occur, we should really have a side conversation about what that looks like or how the board can address it. If we could go to the next slide, please. So when you finally have the application, as I said, you've got to open the public hearing within 30 days. The legal ad and the notices are all the same requirements as you're accustomed to now under 40A Section 11. We talked a little bit earlier that by statute, we're supposed to submit a copy of the application to all local boards within 7 days, so you get that feedback. In addition to having to open the public hearing within 30 days, there's a requirement that we close the public hearing within 180 days of the date that we opened it. So that's usually something that takes a lot of boards by surprise. I mean, I know that certainly with a variance process, you're used to only having 100 days to act. But 40Bs can span several months. You can pretty quickly eat up those 180 days. Like anything under 40A with the deadlines, all of these deadlines can be extended with the consent of the applicant, and the extension agreement should be reduced to writing, and it should be filed with the town clerk's office. And of course, the reason for always keeping our eyes on the clock is we want to avoid constructive approval. Nothing will make you less popular in town than a constructive approval of a 40B. The other thing that is entirely different about a 40B is that everything that you do is just by a majority vote. So your ultimate decision of whether to approve it or deny it is only going to require a majority vote. Same thing with the waivers. It's only a majority vote on each of those.
And on that subject, what does quorum look like? Not that it should come up for our board, but just so that I understand. In a normal proceeding for a variance, we need 4 out of 5 votes. If we are down to 4 members, we need all 4 votes. What does that look like in this case?
Good question. So you're technically a 5-member board with 3 associates. So you need a majority of the 5 members to be able to vote on this. So you need 3 members to show up at each meeting. And you need 3 members to vote in favor or 3 members to vote against it to actually have a vote that takes effect. One thing I didn't look at, and I don't know if you can tell me, but has the town adopted the so-called Mullen Rule under Chapter 39, Section 23D, where a board member is allowed to miss just a single session of a public hearing? And as long as you review all of the materials from that missed hearing and you fill out a form certifying it, you're still allowed to vote on the application?
Yes. That has been my understanding.
Okay.
Yes.
All right. So that's going to apply here as well. So if someone needs to miss a particular meeting, but they can fill out that form and review everything, they're still qualified to vote. You just want to be careful that, so I've had some 40Bs that unfortunately, the hearing goes on for like close to 2 years. And it's pretty easy over 2 years to have someone miss 2 meetings. And it doesn't take long before you're saying, my God, we've only got 3 people left standing who could possibly, act on this application. So, just something to bear in mind. I think it's great that you do have 3 associates, because as long as the associates are attending your hearings and participating. If this goes on too long and you need to bring in an associate or two to actually vote on the final application, you're in good shape.
Can I ask a quick question?
Sure.
When you say it can go on for 2 years, the hearing can go on for 2 years. How does that flow happen? I know it's hard to understand. Did you get my question?
Yeah, I did get your question, and I think the most honest answer I can give you is sometimes you just got to live through it to believe it. Folks would sometimes say to me, well, I actually did have a comprehensive permit that went on for 2 years. And I had a board member who said to me, oh, must have been a really big project, huh, with hundreds of units. No, it was 12 units, So it isn't size. It isn't necessarily, complexity. I think sometimes it's a matter of, was the applicant really prepared when they filed the application? Did they really have all of their plans done or all of their studies done? Because if you're looking at, say, stormwater calculations, you're looking at a traffic plan, and if you're a zoning board that maybe only meets once a month, it doesn't take long before you're skipping a full month, because you're waiting for the developers, engineers to update their plans and to sharpen their pencils, say about their stormwater calculations. You're expecting them to then provide those updated plans and studies to your peer review consultant. Your peer review consultant then needs, a reasonable amount of time to review that data and develop some kind of report back to the board as to whether or not they think, is the applicant, complying with our requirements? Are there still just so many deficiencies? Whatever it might be, there can be a lot of back and forth. Sometimes what also delays is that an applicant might file with the Zoning Board of Appeals first. And then because they have a separate issue under Title V, or maybe they've got a separate issue that arises under the Wetlands Protection Act, they'll then separately but concurrently file with the Board of Health or file with the Conservation Commission. And usually when that happens, the zoning board wants to wait for that other board to complete its process, because that decision might help inform our decision, or that decision might contain some conditions or requests for mitigation that we want to make sure we put in our comprehensive permit decision. So that can slow the process down too. But I will say, by and large, can you wrap these up in, 6 to 8 months if everybody is moving forward in earnest? I really think you can. So once you have actually closed the public hearing, and this is something that's a little bit different than anything you're used to under 40A, is the board has 40 days from the close of the public hearing to deliberate and vote. You still have to deliberate, in public or during a public meeting, but you have a little bit more time for these projects than you would say a typical variance, for example. Once you've voted and your decision is finalized, it has to be filed with the town clerk within 14 days, which is your usual process. A copy of your decision goes to the applicant, and it also has to go to EOHLC. And we did talk about how you could mutually extend any of the timeframes that I've gone through in writing with the applicant's consent. If we go to the next page, please. We talked about outside consultants, and I can't say enough about that, because I think it really is an important tool for municipalities. So I won't cover much more of this. The only thing I will say is, sometimes the applicant will push back on the selection of the peer review consultant, or they might push back on the cost of that peer review consultant. The applicant only has a right to object on two bases. And one is that there's a conflict of interest, meaning that we want to hire, let's say, TEC to be our consultant, and they've worked on maybe this project, or they've worked on another project with the developer, and we feel that's too close for comfort, could be a potential conflict, so the applicant can object and make us look for somebody else. The other thing is whether or not we have actually hired a consultant that has the necessary qualifications. So one thing, for example, that comes up from time to time is that a town may feel that we need to hire somebody to do a hydrogeology study, or to review the applicant's hydrogeo report. Not every civil engineering firm out there has someone on staff who has that particular expertise. So they might need to subcontract out to someone. But, if you get a proposal from an engineering firm that says, hey, we don't have a hydrogeologist on staff, but, we'll give it the old college try and we'll do our best to look at it. The applicant could say, no, you've got to hire somebody who truly has the expertise in that area. So go to the
What
next
are the
slide.
most likely things that consulting firms are hired in for?
I always see them hired for stormwater, sometimes even just for general civil engineering, that they will look at the plans for basic, complete head-to-toe compliance with the zoning bylaw. Everything from whether or not it complies with the plan, complies with the setbacks, height requirements, lot coverage, open space calculations, whether or not your parking spaces are 9 feet wide or 10 feet wide, whether the drive aisles comply with any dimensional requirements. They'll look at all of that. The other thing I do see traffic and peer reviewers brought in, because that, like I said, that's typically not something that a municipality has an in-house traffic engineer to look at the data or the methods that were used. And then hydrogeology has become a bit more popular, usually when we've got some sensitive areas where we know we need to have septic systems, and we think there might be a high water table and a lot of ledge, that type of thing. Those are the three big ones. Every once in a while I see a landscape peer review consultant, and I don't mean to, and architecture, I don't mean to diminish those last two disciplines in any way, shape, or form, but I don't find that boards put as much emphasis on the types of trees or the shrubs that are being planted, or as much into, the color scheme, or whether or not the building just looks like a big hulking mass versus a little bit of, use of setbacks and variation of colors and textures to break up the massing. I see that somewhat, but really the focus is much more on stormwater and civil engineering. So when we're finally at that point where we're deliberating, as I said at the top of the hour, your standard is, obviously it has to be reasonable, but whether or not your decision is going to be consistent with local needs, and whether or not the need for affordable housing outweighs any sort of local rule regarding any of those local needs. And the local needs focus on, things such as health, safety, open space, that type of thing. As I also mentioned earlier, the presumption out there is that there is a need for affordable housing statewide, and it's a pretty high bar for us to get over. I don't mean to use that as a threat that, we will never prevail in a denial of a comprehensive permit, because every once in a while a municipality does identify a local need that the court or the Housing Appeals Committee agrees outweighs the need for affordable housing, but it is a high bar for municipalities to overcome, and particularly where if you're not at the 10%, and if you're not at 10%, you're probably not at the 1.5% general land area. You're simply vulnerable to a 40B. So the best piece of advice I could give is do whatever you possibly can to sort of get to that 10%, and then you can kind of breathe easy and be a little bit more choosy with respect to future applications that come in.
Can I ask also, we talked a lot about the role of this board, the role of other boards. What is the role of public input in all of this process?
As with any of your public hearing processes, you're going to have public comment or ask for public comment at every public hearing. One thing that I typically recommend to zoning boards of appeals is that you open the public hearing and you kind of have, like the 30,000 feet up in the air overview. Where is the project? Let's see the architectural renderings of what this will look like. Let's get a sense of how many units, how many parking spaces, just get the lay of the land, so to speak. And I think it's also a good point at that, a good opening for the public to ask all of their questions that they may have that evening as well. I typically then recommend that after that high overview, that the board think about for their future hearings, breaking it down topically. So for example, maybe you have a night where the only thing we're going to discuss is going to be all the civil engineering aspects and stormwater aspects of the project. And that does a couple of things. One, that tells the developer, I want your engineers here that night. That also tells our peer review consultant, we want you there that night because I want to hear from the applicant's engineer. I want to hear from our engineer. And then it also prepares the public too, that tonight's the night that if you're concerned about stormwater runoff or other aspects, the physical site itself, that's your night to really show up, listen to the engineers and ask your questions. Then you might decide another night, maybe it's a tough spot in terms of traffic. Maybe you have a separate hearing night that the only topic is traffic. And again, you'd have the applicant's traffic consultant, you'd have our peer review consultant. Then maybe there's a night where you can take up landscaping, architecture, lighting is a big thing these days. Folks are requesting dark sky lighting. They want to see the photometric plan to see that we're not going to have light trespass on adjoining properties. Some of those maybe more discrete topics could be combined all onto one meeting night. But part of the purpose for that is, if I'm someone who's opposed to the project and I think, and my biggest concern is traffic, I don't know that I want to get a babysitter or get home early from work, feed the kids and make sure they do their homework, only to go down and find out that tonight's the night that we're talking about landscaping. So that kind of helps, like you said, set the expectations for everybody. But at every single one of those public hearings, in addition to board members asking questions, just like you're asking me tonight, you're going to open it up to public comment as well. And I would strongly recommend, encouraging folks, confine your public comments to the topics that are actually being discussed this evening, because the people who can answer them may or may not be present. But it has the same effect as it does really with respect to any particular hearing you conduct. One difference might be, however, when you're looking at, say, a special permit with respect to a non-conforming, an alteration of a non-conforming structure or a use, your standard there is, whether or not the proposed alteration is substantially more detrimental to the neighborhood, than the existing structure or use is. That's a little little different. That's a little bit more directed to who are the people that are closest to this particular site and who are going to be impacted by it. I'm not suggesting you don't consider those concerns in a 40B, but here it becomes, the local concern that has to be embodied in a local rule somewhere, and it has to have something to do with public health and safety in order to outweigh the need for affordable housing. So I'll tell you, for example, one thing I hear a lot at 40B hearings is how many school-age children are likely going to be living in that development, and what kind of impact is that going to have on our school system when our classrooms are already overcrowded. We can't take this project on because too many school-age children will be in our system. I'm not saying that is not a valid concern for members of the community to have, but it is not a valid basis for denying a 40B. We don't have a local rule that says, or a bylaw that says every development coming into town must have a limit on the number of school-age children that will be enrolled in our public school system. And if you don't have a local rule that you can point to as a basis for your denial of the permit or a denial of the waiver, odds are that on appeal, that denial will be flipped by the Housing Appeals Committee, because if it's not in writing, as far as they're concerned, it doesn't exist. So I hope that answers your question about public input.
Yeah, no, that's great. Oh, that's great. Thank you.
Okay. So continuing on with things that you can consider with respect to the decision, as we've talked about the regional need for affordable housing. Some of the questions I get, well, does that mean it's just the need within North Andover, or is it the need statewide, or is it need regionally? It's the regional need, as for affordable housing. It isn't just limited to North Andover. And obviously you can consider, when we're talking about local rules and how those local rules reflect some sort of public health or safety concern, it goes to the health and safety of the occupants of that potential 40B development, but it also has to do with the health and safety of residents of the town as well. And I covered that if it's denied, it has to be based on a rule that exists and that we can point to. So if we could go to the next slide. We've talked already about some examples of some local rules. The second bullet there, that you cannot deny solely because it doesn't conform to local requirements. That's really where the waivers come in. So one thing I always recommend to a board is, when you're finally at that point where where you feel that you've heard or received all of the information that you need and you've closed the public hearing, and now it is time to start deliberating, I recommend you start with the waivers, because as you start to go through the waivers, sometimes that seems to have the effect of making it kind of clear where this is headed, whether this is headed towards an approval or a denial. For example, I had one board, they granted a waiver from an open space requirement, but then they denied the comprehensive permit because they didn't feel that it provided adequate open space. We lost that case, as you might imagine, because it's kind of a head scratcher of, but you granted a waiver, but then you denied it for the same basis. That's how the votes went, unfortunately. So, like I said, the waivers sometimes help you see what direction this might take. The local regulation that you're going to apply also has to relate to the proposal. This really goes to things such as, traffic. Folks will always complain about traffic. I think it's just where we live in Eastern Massachusetts. We're hard pressed to not be confronted with traffic somewhere in our daily lives. And folks will say, we can't, it's the traffic is already bad. We can't allow another development because it's just going to make it worse. Well, I grant you that the other development is not going to necessarily improve traffic on that road. But if traffic is already bad, we can't hold this developer responsible for an existing condition that is already there. So we need to make sure that the proposal or the rules that we're going to apply to the proposal truly emanate from the impacts of that proposal. And I also recommend that if folks have not had the opportunity previously to review HLC's comprehensive permit guidelines, there are some good resource materials on their website, whether it's the comprehensive permit guidelines, they've got guidelines relative to the subsidized housing inventory. There's some good things in there for a zoning board in particular to review, because it does help kind of refresh your memory of the things that we can take into consideration or cannot when the hearing actually comes. So the next slide. So as I said earlier, if you're not at 10%, you're vulnerable. So bear that in mind and try to shape the project as best as you possibly can. One other thing that you're allowed to do is, request appropriate mitigation. We've got to bear in mind that we can't impose a condition that renders the project uneconomic, but that doesn't mean we can't demand something. That doesn't mean we can't demand some screening, some fencing, some changes in design that might make the overall project fit better in the neighborhood. All of that is still available to you as long as it's within reason. And I think the next slide, we continue on with conditions. There we go. I think we have covered most of this already. I will say that most of the conditions that I see that do get imposed deal with some sort of infrastructure. So going back to the traffic concerns, if the developer can fund or provide funding to have the lights or the signals on a particular stretch of road, have them reconfigured so that they're in sync and that helps traffic flow better, that would be reasonable. If the developer is required to maybe create a right-hand only turn or no left turn coming out, something that helps traffic flow better and maybe cause less congestion or pose less of a safety for public safety purposes in terms of traffic accidents, you can impose all of those conditions. You can request more landscaping be planted. You could request, like I said, dark sky lighting. You can push the envelope about as far as you feel you can. I think the developer will start to push back when they think that you might just be going a little too far afield. And I think it needs to be sort of in proportion to the size and the impacts of the project that, we might look at a 10-unit project a little bit differently from a 100-unit project, for example. But don't feel as though just because this is 40B that our hands are tied and we can't request some kind of mitigation. You can, as long as it's within reason. One question I get asked a lot is, well, it's just too many units. It's just too much. Tell them to decrease it. We can't just arbitrarily say, knock 20% of the units off and we'll be happy. Because remember, the developer long before getting to the zoning board process has developed this whole pro forma of how many units they need in total and how many of those could be affordable units so that overall they can afford to build this project. And every time you take a few units off, you might be skewing those numbers a little bit. I'm not saying you can't propose a decrease in units if we've got some sort of valid reason for it, such as, they've got to do an on-site septic system, and their on-site septic system is simply not capable of handling the flow from these number of units, or if they're not going to have enough parking on site and we aren't willing to grant a waiver from parking, or maybe we have granted a waiver from parking, but we still feel that there's not going to be enough parking on site and there isn't sufficient off-site parking. Maybe that's a basis also to talk with the developer about the potential for decreasing units, because there's got to be like some other need that has to be served. We can go to the next slide. We talked about appeals earlier in the conversation, so I think we can skip that one. If we go to the next one. So modifications, after you've actually approved a comprehensive permit, the applicant can come back and can seek a modification. The modifications, you might be used to the terms, is it a minor or a major or minor modification? The 40B world uses the term substantial or insubstantial. Doesn't really roll off the tongue like major and minor, but if you get a request in for a modification, the board only has 20 days to take that up and make an initial determination as to whether or not they think that modification is substantial. And if it is substantial, it requires a public hearing. Or we think it's insubstantial, and as an insubstantial change, the board can just grant it right then and there in the context of a public meeting. You don't need to advertise a public hearing for it. If you don't have that initial meeting to determine whether you think it's substantial or insubstantial within 20 days, then that modification is automatically deemed approved and it gets incorporated into the comprehensive permit. There is some guidance in the regulations as to what the Housing Appeals Committee would consider to be a substantial versus an insubstantial modification. It is by no means an exhaustive list. And sometimes even a board will say, well, I don't care what the regulations say. We think that what the applicant is proposing here is substantial and warrants a public hearing.
So who makes the determination about whether it's substantial?
The Zoning Board of Appeals. So you do that within 20 days of that initial
Right.
notice from the developer.
But then, so does that mean that we need to have a full meeting? Do I make a declaration as chair?
No, you would have to have a meeting. So if it's not falling within your normal meeting schedule, you will need to schedule a special meeting to make a determination. Or, like I said, you could take no action and it's just deemed approved. And maybe the requested modification is so insubstantial that you don't think anyone would necessarily be upset if it was just constructively approved. I think the better thing to do is convene a meeting within 20 days of receipt of that request, make that initial determination. If it's minor, you just approve it right then and there. If it's major, you tell the applicant that we are going to go ahead and we are going to schedule a public hearing within 30 days. And, the same process that you followed when the comprehensive permit application was filed with, a legal ad in the paper, notice to abutters, et cetera. And then you have a hearing and you issue a modification decision. One thing to bear in mind is you can only consider the topic or the area of modification that the applicant has requested. So in other words, if the applicant's before you because they need to adjust the roadway layout for some reason, that is not the time for us to talk about changes in stormwater or the height of the building, for example. You are limited to confining yourselves to just what has been requested to be modified. And again, sorry, go ahead.
In your experience, how common are these modifications?
They are fairly common, to be honest. Sometimes they're as simple as, like I said, a roadway layout needs to be altered because they discovered some underlying conditions that they didn't initially know. I've had requests come in, for example, perhaps they were originally going to be single family homes, and now they want to make them duplexes. Or it was originally approved with an age restriction of 55 plus, and now they've done a study that says that's really not the population that needs to be served. So maybe they come in and ask for removal of that 55 plus requirement.
And
things like that. It's pretty common to seek a modification.
okay. And with the 20 days and the 30 days, is the 30 days after we determine that it's substantial, or is it
Yes.
in 30 initial filing?
No, it is 20 days to have that meeting where you decide substantial, insubstantial. And then once you have said, we feel it's substantial and needs a public hearing, it's 30 days from the date you've made that determination. Okay. And the applicant, if the applicant disagrees, if you deny the modification or they disagree with some condition that you impose with respect to the modification, they can appeal that to the Housing Appeals Committee, just as they can the original comprehensive permit. And that brings us to the end. If anyone has any further questions.
I'm going to open it up to the rest of the board because I kind of dominated the questions here, folks.
So I have a question. If we go 6 months or more than whatever, what happened to the other cases? Because typically if something gets pushed off to the next month, that's the first topic we talk about. Like, what about other cases? New projects.
Ms. Murray, you need to unmute yourself. I think you got muted because of the echo.
Thank you. It's a good question. Often what some zoning boards will do, because 40Bs can be fairly contentious and draw a pretty big crowd, and they are a little bit more involved in terms of the public hearing than, say, someone who just wants to put an addition onto their kitchen or something. Often zoning boards will schedule 40B hearings on a separate night, just for that purpose, that we've got our regular business and we don't need people who are here for, a few fairly straightforward findings or variances. They don't need to sit through 2 hours of a 40B hearing, for example. I've got other boards that say, I can't get people to meet more than once a night. People are busy, people have other commitments. So it's all got to be done only on our regularly scheduled meeting. If that's the case, then you've just really got to take a hard look at those meetings. And my suggestion would be take all the other business up first and save the 40B for later in the night, because maybe you can easily dispose of the simpler cases and let those people go home. And then you buckle yourselves in for the 40B hearing for the rest of the night.
Yeah, that's an important consideration for us to think about.
Anything else?
So you've thrown a lot at us tonight. There's a lot to track as far as applications go and whatnot. And what documents the town has in place already and whatnot. Who sort of coordinates all of these issues, the timing issues, the housing production plan and all those questions that you've brought up?
Well, that's, again, good question. And I don't know whether Jean or Paul might have some insight. In some communities that I deal with, it might be the planning director or the planner who provides that kind of support to the zoning board, because it's a 40B and because they might have the staff and the resources to help. I've got a smaller town where they don't have any in-house planning staff, and they have, a part-time administrative assistant. So you're looking at the person who is keeping all the people rolling in the right direction and keeping the calendar and keeping track of, who's making it to the meetings, who's missing meetings, who's certifying that they reviewed everything. It can sort of run the gamut. So I don't know who traditionally supports zoning board meetings for you now. But I do also recognize, even if you get support now, say sometimes you might have your building inspector, for example, might attend most of your zoning board meetings. When it comes to a 40B, it might still be somebody else, such as someone from the planning department who provides that support. But I think that is an excellent question to speak perhaps with the town manager or others about, because you do need a little bit more support than your average application for this. Absolutely.
Yeah, and I think that that's a conversation I'll definitely need to have with the town administration.
Thank you.
And then towards the end, you said, if they had a modification, they have 20 days for us to have a meeting. Could any of those meetings be a Zoom type meeting, or does it all have to be in person, or how does that work?
They could absolutely be Zoom, hybrid, in person, whatever works best for you. As long as I think the latest extension on hybrid meetings is now taking us out to 2027, if I remember correctly. So yes, you could have that meeting by Zoom.
Okay, because we can't have most of our meetings right now by Zoom for regular zoning board business.
Yeah, I will say I do find that planning and zoning board meetings done remotely are difficult, because people need to see plans, and we need to know, well, where are you talking about? And even for those of us who might be a little bit more technologically savvy, I hate looking at a plan on my laptop or my iPad. I like to be able to see the big plan or blow it up. And I always have some sympathy for folks that are, watching from home, that are trying to ask questions and they're saying, no, not that page. No, not that page. No, that one. Okay, a little to the left.
I was going to say public participation is definitely far better in person. Any other questions from the board members? Or from Paul or Jean?
Nope, I'm all
What's
set.
the-
Thank you.
What's the timing of this, when we expect to have our first hearing on it?
Nothing has been filed yet, so we don't have a timeline. Except for the notice that, stuff with the state is moving forward, but the official list of waivers has not been filed, so we don't have any specific business to plan. But this is in preparation with the idea that this or another item may come down the pipeline, and it is good for us as a board to be educated and prepared.
So regarding the filing fees and other regulations that Carolyn suggested we have in place, those aren't things that our board can address.
They are. So I think the idea there is that those are regulations that we have the power to set. And so I have on my to-do list to discuss them with our town administration and learn from those a little bit, and if there's something that needs to change, we'll bring it up to the board.
And when, if we were trying to do a separate meeting for the 40Bs and keep everything else separate, do we discuss that at our next meeting in August, or do we wait until the 40Bs in front of us?
Well,
how
if we change our regulations, it only for the case, it sounds like, and Ms. Murray, you can tell me if I'm wrong, that what matters is the regulations that are in place when the case is filed. And so if we would need to make any changes we're going to make before it gets filed for it to be relevant for this case.
No,
Correct.
I'm more thinking if we have a second meeting per month for the 40B, like we have a separate meeting for the 40B and keep our second Tuesday of the month for other people. When do we have a conversation about that, or how are we going to proceed with that?
I believe we're allowed to discuss planning and logistics for the board offline. I don't think we need to discuss that at a public meeting. And so I have also on my to-do list to email you folks and ask you about how we want to structure meetings in the event of 40B. Because that does not cover deliberation on the merits of any case, and so it does not fit within the open meeting requirements.
Do we have any, well, is Ms. Murray our legal consultant for the permit, or is this a one-time thing tonight?
This is right now a one-time thing unless we decide that we need to hire KP Law Services to push up something on the legal side.
I believe Andrew Shapiro, though, is going to pursue technical assistance for the board, so.
Okay. And that goes, I think, to Frank's earlier question about how we're going to coordinate some of these things. So I will make sure to just keep in touch with Andrew on this.
Well, if no one has any other questions, I will wish you all good luck with the 40B, whether it's with my assistance or with someone else. I hope that at least this has been useful, and that the PowerPoint is something you can refer back to. And I have an awful lot of sympathy for boards when these come in. So if there's
This has been
anything that
enormously helpful.
I can help.
This has been enormously helpful, and it's given me a ton to work on behind the scenes.
Good.
So
Good.
thank you so much.
Well, thank you.
Thank you.
You've been, it always makes it much more lively when you ask questions. So thank you for that.
Thank you. All right. Well, with that,
Thank
do
you.
we have a motion to adjourn?
So moved.
Do we have a second?
Second.
All in favor?
Aye.
Aye.
All right. We are adjourned